Well, like all cases, sooner or later, sanity prevails, people come to their senses, and also there was a big bust. The dot-com boom had busted, so people began to think, hey, come on, guys, the fun's over. We can't keep on going like this forever. Let's settle this case, which they eventually did. There was a press release that came out on March 7th, 2002. They settled the case, and some people stated that Amazon.com was much too aggressive. They mentioned Jeff Bezos in some of the press articles. He was criticized by pushing the envelope a little bit too far. And also, some people criticized the Patent and Trademark Office for what was said to be a clear lack of understanding of software prior to granting the patent claim. Now, I can't fault the examiner. I was an examiner. Examiners only have available to them patents and prior publications that they can access from their desk. The trial judge, she heard the testimony. She eyeballed the experts on both sides. The examiners don't have an opportunity to do any field investigation, and she was someone who was nominated by a senator, appointed by the president with the advice and consent of the Congress, and she also has some very smart law clerks, like recent graduates of Harvard. In a pinch, she might even take someone not from Harvard, but she has lots of facilities to determine one way or the other, yay or nay, and she made the decision which was consistent with what the examiner said. So I wouldn't fault the office. It's a matter of interpretation, and sometimes you got to take your chances. Now, before I discuss rewards for creativity and public interest, I would like to announce that although I like to think I've answered your questions about copyright and patent protection pertaining to computer programs and software-based inventions, candor forces me to admit that I probably haven't. I've left some business cards here. I'm going to be on campus for the next few days. If you want to talk about any of these issues, please let me know. My contact information is here. My cell phone number is there. If you'd like to talk to me, or right after I leave, you can send me an email. I'll give you a consultation. It's free. That's making you an offer you can't refuse. Before I talk about reward for creativity and public interest, I wonder if there's some people who have some questions. Professor, I think there was a topic or two that you had mentioned earlier. If not, I'd just like to wrap up with some references. Okay. The patent and copyright statutes have to provide some reward for creativity in order to incentivize people. The issue of the patent and copyright statutes providing some reward for creativity was recently debated in, I saw on camera, was recently debated in the case of Elrod versus Ashcroft. It was a copyright case which did not have to do with computer programs, but the issues were debated by Justice Ginsburg, speaking actually on behalf of the majority, and Justices Stevens and Breyer speaking for the majority. Justice Stevens characterized the reward for creativity as a secondary consideration. Well, Justice Ginsburg saw things differently. She observed that Justice Stevens' statement was an understatement. It understates the relationship between the rewards and the progress of science. The economic philosophy behind the copyright and patent clause is the conviction that encouragement of individual effort by personal gain is the best way to advance public welfare through the talents of authors and inventors. Copyright and patent law celebrates, that's the language she used, celebrates the profit motive, recognizing that the incentive to profit from the exploitation of patents and copyrights will redound to the public benefit by resulting in the proliferation of knowledge. The profit motive is the engine, that's language she used, is the engine that ensures the progress of science. Now, I commend to you, computer scientists, be as creative as you possibly can. Don't be shy about responding to the profit motive. Don't be defensive about responding to the profit motive, provided you make a commensurate contribution to the progress of science and the useful arts. Thank you for the opportunity to make this presentation. I hope it's been interesting and informative.